What's up, everybody? How you doing? This is your brother Sylvester Moore-Eel from Thctrust.org. You should follow along today. To do that, you'll have to have a premium subscription on the website, which is $32 a month. But the basic membership is free. And to do that, you just go to the website, thctrust.org. Click this thing right here that says create a new account if you don't have one, and that's where you start. But if you already have an account, go ahead and log in. And you can follow along today by going down here to the advanced topics and clicking mortgages. Actually, so in the last video I left off and I began to talk about the difference between discharging a mortgage and canceling a mortgage. And that's what I'm going to finish talking about in this video. Then we're going to go to the fiduciary appointment and authorization, because as we know, when you're doing some type of discharge, everything starts with giving your instruments to a fiduciary, whether that be the CFO or, in this particular case, what we're going to focus on in this discharge procedure that we're discussing is the clerk of court. Something I stated in an earlier video, that's actually where the discharge occurs. Sometimes we're off focus because we're putting the majority of our emphasis on the beneficiary bank. And we're talking about mortgages, of course, because we think that, oh, it's them who have to accept our instruments and do the discharge. Usually, I would say the majority of the time, all the times that I've seen, your private presentments, when they go to the CFO of the financial institution, they end up getting ignored. They don't get honored. And you can look for the latest and greatest process all you want, but they all go to the same place and they always get ignored. But again, the nature, how we're proceeding here is different. The ultimate responsible party of discharging the mortgage through what we're explaining here is going to end up being the recorder of the deeds or the clerk of court. Why? Because they have their constitutional duties, which is under the oath of office. Then they have their official duties, which is specifically, both of those things you can rely on them to have to do, because if they don't perform their official duties or their constitutional oath, this ties into the insurance policies and everything else that gives you enforcement. So what makes what we're demonstrating here in this entire series, what makes this more likely or stronger process to have success than everything that's out there? Well, one, this strategy was built with enforcement from the very beginning, because enforcement comes down to this. What do you do when they don't accept your instruments? There's a lot of different things you can do, but ultimately you're setting everything up for a breach of fiduciary duty and obligation. That is the direction you want to go with it. But anyway, let me jump back on this topic real quick before we go further into that. And that is canceling versus discharging the mortgage. And I'm not referring to the actual instrument that you record into the county to satisfy the mortgage deed, because that's going to mostly depend on the state that you reside in and how they do business, whether the document is called a release of lien, cancellation of lien, discharge of mortgage, or what have you. What I'm referring to in this video is the one of two approaches that you're going to take, or you're going to have to take. The majority of people, 95% of the people that I have ever come across since I've been in this field of research, they go the way of cancellation. What I mean by that is they argue that the bank is not the holder in due course. They argue that they have not been given full disclosure, etc., etc. They may argue things under the Fair Debt Collections Practices Act, a bunch of different things, fraud, right? All of those are arguments that you either have to bring to the court or that you do some private administrative procedure which ends up certifying that fraud has taken place. Meaning you may have done this private administrative procedure and defaulted them, and according to the provisions of the default, you have proven that all types of fraud exist, at least according to your procedure. And as a result of that procedure, you may sue, file a quiet title action, or even go one step further and do a rescission of deed, like rescinding the mortgage deed or revoking the power of attorney. But if you notice, all of these things, I say they lead to cancellation because, when we speak of discharge, we're talking about discharging the obligations, discharging the duties, right? Things that a fiduciary would do. So a discharge of the duties or the debts would be an honor, if you would say. It's a commercial honor. Whereas in challenging or arguing about the validity of the debt is a dishonor. So generally, these things cannot be mixed. So I'm just saying, when you put your strategy together of discharging or canceling, really put it together, make a solid strategy and stick to it. But you can't mix arguing about the validity of the debt and then trying to discharge the debt at the same time and remain in honor. These are two entirely different things. So as you developed or put your administrative procedure together, think about this. And this is going to be as hard for a lot of people to do because they want to argue and discharge it at the same time. Now, I'm for discharging it, not rescinding and canceling out, although that is, I've already investigated that field of study. I've seen numerous people do that. We've did that. And there's reasons why I believe that that's not the way to go. One is because, as I stated in an earlier video of this series, let's be realistic. You're fighting the world when you say that your mortgage is fraud, as though everyone else's in the world isn't, although they've all been created the same way, the same institutions, from the courts, the judges, the counties, the debt collectors. They all participate and they feed off of this thing. So you're asking someone who's not liable, that probably has no motivation to see things your way, to call this whole thing a fraud and honor it when you put your cancellation or whatever in there based on your administrative procedure or whatever, that there's proof that there's fraud. I get it. I mean, that's the strategy I used to use. However, I've learned that there's no enforcement in that strategy. I'm not going to say that there's no enforcement, but obviously we haven't got the results. And I'm talking about everyone, no matter what you do. And people who tell you, oh yeah, no, we have success, ask them to qualify what success is. I can tell you how to file a quiet title action to buy you time. You can file FDCPA claims, RICO claims, and all of those things. So the last thing I want to say about going the route of rescinding, revoking, and canceling for fraud and spending a lot of energy in that, the best of that strategy, what I've seen have near success, didn't end up in them ruling in your favor in court. People have figured out, well, I can do this administrative procedure and then record the cancellation of deed document in the county. Now, what can happen has happened numerous times for people. Again, I haven't seen anybody with success, complete success, going about it by trying to cancel the mortgage deed, just canceling it based off of fraud or whatever. Those records, although you may have success recording them, you should have success recording them, because when, again, as we stated earlier, when it comes to recording, it's not about the clerk's discretion. And you guys probably don't believe it. Somebody's going to be like, no, in my county, there might be one or two of them, but the majority of these places, even though they reject you all the time, it's probably because your form isn't correct. And there's something that you're lacking, but they're not going to tell you what it is. But that being said, I can help you with that stuff. I do coaching sessions, by the way. Real quick, look at the screen if you're just listening. If you ever log into the website, this is the link for coaching sessions, because a lot of people say, I don't see anything. It's right here. Okay? And it's right here. Okay, so now I lost my train of thought a little bit. What was we saying? I was talking about, oh yeah, the cancellations. When you record those documents, I've seen where they will get removed from the docket, stricken from the docket, sent back to you, crossed out, all of that, basically saying, we're straight up not honoring this. And then you're stuck like, how did they do this? I didn't think they could remove documents from the record. So they dishonor it, remove it from the record, send it back, and then the foreclosure attorneys starts foreclosing on you again under that deed, right? So As we talk about discharging as opposed to just canceling, um, this is a whole new paradigm or way for people to deal with the mortgage situation. One, because it stacks all the cards in your favor from the very beginning. You know, people are used to going into the court and arguing and filing these different lawsuits, spending different money on things to stop them from foreclosing. But if you notice, as I said before, and this is very significant, if you don't pay close attention to what I'm saying, you've never seen it any other way. You've never seen them foreclose on anyone in court. The first part of the procedure is identifying the deed or the charging instrument from which they are declaring to have their powers. Where they get the powers, because you transferred the rights at some point when you did the mortgage and the security deed. So what I'm suggesting is you discharge the mortgage deed with a bond, or maybe a series of bonds, your fiduciary appointment and authorization letter to the person whose official duty it is to discharge deeds anyway, and you let them do what they always normally do. The only difference is this time you're giving a fiduciary appointment authorization instruction. You're creating a binding contract with the clerk to discharge the mortgage, instead of just simply sending a document and letting her do her normal duties. I feel like, again, when you send her just the documents and let her do her normal duties without any type of enforcement behind it, later on someone will come and strike those documents, cancel them for the records, and you really have nothing much that you can do about it. And this is going to become clear what I'm saying as we dive into the discharge procedure, which now we're going to do next. But first I got to tell you something. Obviously, if you're discharging a mortgage, a car, or anything, there's going to be some instruments, probably a coupon or bill of exchange and or one of those things. And of course, with the mortgage, we're talking about there's going to be a bond. We're going to skip over those instruments right now because the focus of this is not to demonstrate to you what the instruments should look like, what should be written on them, and all of those things. That's a whole different study within itself. And I'm not the only one, or I'm not even qualified. Really, I have my understanding. I create my own instruments. But what I'm saying is, it's not the instruments that determine whether or not they honor your discharge process. It's not how pretty the instruments are. If that has any percentage of it, maybe it has something to do with it for sure. But listen also closely to what I'm telling you, because this is where people have went wrong in the past, even where I have went wrong. Put so much emphasis on trying to find somebody's instrument on the internet or creating the right instrument, and overlooking the fact that everything is about contracts, and what's most important is your fiduciary appointment and authorization. Because again, that's the most important, because you need enforceability. The enforceability needs to connect to a couple of different things. Primarily, your ability, having the evidence and the facts to prove a breach of fiduciary duty, and also having the facts and the evidence concluded so that you potentially can make a claim against any surety bond or insurance policies that's tied to the constitutional oath or oath of office. By the way, those are two different things, the constitutional oath and the oath of office. But, you can ask me offline or go into that, or you could just kind of dig into that and find out yourself. Okay. So just to recap where we're at right now, we went through all the videos in this series. You understand that the discharge happens at the county level. We're kind of thrown off and think that it really has to do with the beneficiary or the lender, because usually in a normal circumstance, what happens is they send the cancellation or discharge instrument to the county clerk, and then the county clerk does her official duties by releasing the claim by making the entry in the margin of the recording of where the deed is. That's the actual discharge. So, and we figured out, okay, it's not the lender, it's actually an instrument that causes the clerk to take these actions. And we've also figured out, or at least I have told you, that when it comes to recording deeds or records in the county, it's all about the clerk's official duties, and it's not a matter of discretion. Now, if you are being refused things strictly as a matter of the court's discretion, or then that most of the time it has more to say about you, your presentation. I hate to say it, but maybe your appearance. You may come off as if you don't know what you're doing, right? Or the majority of the times it's your documentation is wrong and you're unwilling to accept it. You think they're just trying to stop you. No, sometimes your documents are just wrong. If you're being jammed up and you have that situation and you're at a brick wall, you can't figure out which way to go, have a coaching session. I could probably assist you or give you a better perspective than the one that you already have. All right, so all that being said, now we can get on to the fiduciary appointment and authorization. Again, we're under mortgages and discharge, but again, the first part of your administrative presentment is going to be presenting your private instruments to a fiduciary. Now, actually, this discharge mortgage procedure that we've been discussing to this date, and this is where I don't want to confuse you, but it's going to require 2 presentments, right? 2 presentments to discharge your mortgage. In the grand scheme of things, that's not a big task to ask of you. But the first presentment, of course, is going to go to the CFO of the bank or his agent or direct appointee or whatever. That's going to be the first one. And that one, I would probably put my 1099s, 1099 A, C, or whatever. And those instruments are not going to be what causes the discharge. So I'm just trying to say, whatever you put in there, whatever you've come to the conclusion is necessary to be in there for the canceled account, deed, or whatever, go ahead and put it in there. But your success or failure is not predicated upon them accepting it. Matter of fact, we said there's going to be 2 presentments because, as it has been since the beginning of time, the CFO is going to ignore it. But it's still due process. So you have to do a solid presentment just as though he was going to accept it. In that presentment, you'll have various records, including the discharge and the satisfaction instrument that all he has to do is send to the county. But the fact of the matter is he's going to probably ignore it and reject it. And this is why when that happens, you have to have a notary's certificate of default or dishonor, the ability to have proof. That's what the notary certificate is. You can have proof of the contents, the instruments that were presented, and proof or evidence of the default. Again, that's what the notary certificate says. These would be the proof or the support that you need to take an action. Now, what action can you take? Some of you are thinking, well, I can run down there and record this document, record that document. You could, but what would be better is that if you appoint somebody else to do it, you appoint someone else as a satisfaction agent or a trustee for a specific constructive trust. The constructive trust to discharge the mortgage, right? That's a constructive trust. So here's the science behind what we're going to look at, or what we're going to talk about, what I want you to think about. I keep stating that you could take this cancellation or discharge mortgage deed and go down to the county. Where's the picture of it? And you can record it tomorrow. Oh man, the screen's going to move so slow today. But here's the document, right? Because the form is there. It references, it has the legal description of the property that it references. It has everything that's necessary. So you can record it. But if you walked in there to record it, you can still record it, but you might be met with resistance. For example, in LA County, last time I checked, they start requiring your ID. So that now you're putting facts on their record. They can be like, well, your ID says this and you're this. So they play little games, but the thing is, if you're in one of those places where they play games for you walking stuff in, then you have to registered mail, send it to the clerk, registered mail. And that's how you do it with your cover letter. Or you can have a notary or someone else, an officer of the state, present it to the clerk and get a signature for it. There's different ways you can do it, but don't get hung up on the fact that they're not going to record my document. If they're making a personal determination against you, which they're not supposed to, just get around it. You will be able to get around it. And if not, holler at me and I can let you know what you need to do, which might be correct your document, or I'll let you know how it's done. So we know when I say you can go record this tomorrow, no one's going to stop you. And what happens is you go in there, you pay the filing fees to the clerk, and they record it. Why? Because it's their official duties. That's what they do. They record documents, and that's what they have to do or they get in trouble. So they will record it, right? So then let me ask you, put on your thinking caps for a second. What will happen if I sent this document to be recorded, but I also had a Form 56 fiduciary appointment making the clerk the fiduciary with respect to my constitutional right to possess and protect property under Article 1, Section 1 of the New Jersey State Constitution. Look at your state and federal constitutions, right? Because there's a bunch of goodies in there. And when you accept the oath of office, a constitutional oath, what you're doing is you are creating a binding and enforceable contract under that agreement, that pledge. So that's where your enforceability comes from. So when you accept the oath, constitutional oath, you're making that person a fiduciary with respect to your constitutional rights and or the laws of the United States, i.e. acts of Congress. This is the power behind accepting the oath, being able to bind that fiduciary to perform under in the capacity of protecting your constitutional rights or carrying out the duties, which is supporting the laws of the United States, i.e. acts of Congress. And that'll come up different places in the process as we look at the enforcement, right, or the fiduciary appointment contract, because that is the enforcement. So I stated, imagine that you're sending this document prepared, registered mail to the clerk of court by name, restricted delivery with the appropriate filing fees and the cover letter letting them know to record the instrument. And you don't have to talk about the entry in the margins. That's automatic what they do. But you also put the Form 56 in there, the fiduciary appointment and authorization contract, which becomes binding upon them, right? We looked at the document earlier in the series looking at the formation of the fiduciary relationship. Them knowing that they have received appointment as fiduciary based off of their public pledge, constitutional oath, and if they don't respond with some type of affidavit saying that they don't have the legal capacity to be your fiduciary for whatever purpose, then they assent to becoming your fiduciary. So there's no way out of it. Now you have the enforceable contract, and now you can expect performance or breach of fiduciary duty, which connects directly to the collateral of the enforcement contract. The collateral is connected to the proceeds, which is the bond and the insurance policy and all of that. So if you are discharging with bonds and commercial instruments, and you give these things to the fiduciary, there, for example, your bond to discharge the mortgage is probably not going to get recorded to the point where you can look it up, just like you can look up a quitclaim deed or a warranty deed. Those things, as a matter of fact, I read this somewhere too. Basically, those instruments, they go somewhere else, but they are referenced in the margin entry that actually discharges it. That's why when you go do title searches, you don't usually see cancellations or discharges of mortgage records like this one. You don't see those things. You just see other deeds. But you can find out, oh yeah, that deed's been discharged. They have a different record in which they maintain. So I state all that to say, I believe your financial instruments, which in the case of the clerk of court or the registrar of deeds, it wouldn't be 1099s and all of that. I don't think. Maybe you could. I think the 1099s is part of your process with the lender. But with the clerk, what's most important is your fiduciary appointment and authorization letter, and the bond for discharging the mortgage. Because if everything is correct, they won't make a judicial determination. You're not going to have a problem recording the bond. You know, they're going to be forced into a type of silence. They won't be able to say anything to you. So the whole gist of this is you want to make sure everything is right, because you're going to force them in a position to have to perform, right? Because look, if they didn't perform, what is going to be the reason why? What are they going to tell you? Why are we not recording this document that's in the proper form that we do on a daily basis anyway without making any type of discretion? Are we not going to do it now because you appointed us as fiduciary under our constitution, under our constitutional obligations, and that you've tied our insurance policies and our oaths and our insurance policies and our bonds to this one act of recording your discharge instrument? Are they going to make the determination that you're not entitled to record it? Well, what would they make the determination on? They're not even a party to the instrument, and there is no adversary there. You know, are they just going to argue for their own position? So I just want you to shift your mind into the thing so you can see the bigger picture of what's going on. And of course, we can only speculate what they're going to do because we don't know. You can't predict what the individual is going to do. But what I think they're going to do, based off of my experience with discharging debt and developing procedures and interacting with these public officials, seeing what makes them move, my gut feeling is if you carry forth the way that we've laid out to this point, you're going to put them in an extremely difficult or hard place. And when they weigh it all out, they're going to say, it's better just to discharge this. You're not going to put my job, you're not going to put my ass on the line for this. So, you know, if the bank has a problem with it, the bank needs to sue you. And that's the whole thing, right? Instead of you trying to sue them under quiet title action, RICO, Fair Debt Collection Practices Act, unlawful foreclosure, and all of that, spending the resources, make them have to go into the record and sue you and state that you did something fraudulent or whatever. But if you have a record to protect it, and you already know that they have no standing and all of these other things that you've been fighting for the years, then you don't have to really worry about that. It doesn't seem like it's financially feasible because these attorneys don't just jump up on their own accord and be like, I'm gonna swallow the legal fees to pursue this guy in court so I can get a judgment, so I can strike his documents for the record. And the other thing is, it probably will take them 1 or 2 months before they even figure out that you've recorded these documents. And you really don't have to give them notice. Well, you do give them notice. That's what your administrative procedure is going to do. We're going to kind of look at some more of that as we carry on down the road of this long series. So ideally, after the CFO, beneficiary bank, defaults on his obligation to discharge the mortgage based off of the federal laws that you give him and the instruments, you'll certify that default with a notary certificate of protest or some type, and then you will develop your private administrative process, simple process, for the satisfaction agent, or let's just call her the fiduciary, which would be the clerk of court that you appoint to discharge this. So now, when the clerk records this instrument, when you have a page and book number for this instrument, we can only come to the conclusion that the clerk and the county has remained in honor, right? So I hope y'all get it. Tell me if you get it. Then leave a comment. I'm gonna end this video right here. Just tell me if you get what I'm trying to express here. I'm going to state it one more time. The discharge mortgage instrument, like any warranty deed, quitclaim deed, they're going to record it anyway if the form is correct. It's not going to be about personal discretion 95% of the time. If that's not your experience, it's because something's wrong. I can help you with that. This is what I do. I research these things and I come up with solutions. So they're going to do it anyway. But when you give them a fiduciary appointment and authorization contract, and you give them notice of it, registered mail, restricted delivery, and that contract spells out exactly what you're requiring them to do, which is in the which is in the scope of their constitutional duties, their official duties of their office, and an act of Congress, which is the laws of the United States. You show them why it's within their ability and duty to do this, and then you let them know that, hey, I expect to see performance. How do you know if they perform? There's only one way to tell. If they do what they were going to do, even if you didn't send all of that stuff. Now, if they choose this time, oh, we're not going to record this deed, they're directly, specifically trying to tell you that we have dishonored your position. We have dishonored the fiduciary appointment and authorization. And if they hadn't sent you back anything in writing to tell you point for point why, then they're also telling you we don't give a damn about that constitutional oath and the oath of office, because we're not going to follow that. That's what they're telling you. Now we're going to go forward, but I don't want to lose anybody. So leave some comments under the video. Tell me if you've watched the series up to this point, do you understand where we're at? Ask any questions, because until I get an idea that people are even following where I'm going, there's no reason for me to go any further, because you'll be lost.